So when you hear someone say that it's unconstitutional, ask them, well, what part of the Constitution are you referring to? And if they can't answer it, that's red flag number one, because Article 2 is specific and it delegates the authority specifically to the President of the United States, the executive, to enforce the laws of the United States. Period. End of story.
Right. Welcome to the Republic Podcast, where history meets scrutiny and facts matter. Join Rob and Lou as they dive deep into the foundations of American democracy, dissect the laws that shape our lives, and challenge the narratives behind today's headlines. From forgotten chapters in the U.S. history to the legal truths they didn't teach you in school. This is your front row seat to get informed, unapologetic conversation. We have an American republic, if we can keep it. Now, let's get started. And we're back again. We're alive again. Cheers, brother. Cheers, everyone out there.
Cheers, my brother. Cheers, everyone.
Lou and Rob, and we're here for the Republic, If You Can Keep It podcast. We are on another special report number 3, and this time we're dealing with the recent Supreme Court decision, or really lack of what I would call lack of Supreme Court decision on the presidential use of National Guard in relation to assisting federal authorities.
Yeah, and this is more than just the last Supreme Court dabbling in it. This is the whole issue. Can the President of the United States mobilize, federalize Guard units from different states to go to different jurisdictions within the United States, as he would say, meaning President Trump, to help facilitate and protect federal assets, meaning both personnel and places, in the execution of and enforcement of federal law.
Right.
Now, that is the issue at hand, but we have a whole different number of sub-issues there, because as a starting point, we have the difference between when President Trump mobilized and put Guard units in the District of Columbia versus his desire to put them into different cities in different states: Portland, Chicago, Los Angeles,
Memphis. Yeah.
Right. So as a starting point, let's talk about the difference in the jurisdictions to which these Guard members would be sent. So the first one is about the District of Columbia. And there's of course litigation, because when President Trump sent the and mobilized Guard units to be sent to the District of Columbia, there was a lawsuit against him to say, no, you can't do that. You've overstepping your bounds. And I'm looking at a decision from the United States Court of Appeals for the District of Columbia Circuit, filed on December 17th, 2025. This is docket number 25-5418. District of Columbia versus Donald J. Trump in his official capacity as President of the United States et al. And the issue here is, can the president mobilize and deploy National Guard troops to the District of Columbia to address violent crime and to ensure public safety? That's how the issue was framed in that case. And the Trump administration cited Title 32 of the United States Code, Section 502, subparagraph F. And what's really interesting in this, when I first looked at it, the number of amicus curiae that were brought into this, who was sought to be brought in, was extensive. And for those of you who don't understand, amicus curiae meaning we're not the plaintiff or defendant here, but we have an interest. We believe we want to be able to chime in.
Friends of the court, right?
Friends of the court. So they have a lot of people chirping in the ears and filing briefs on this matter. And initially, in the District of Columbia. The district court in the District of Columbia basically said, you know what, we're going to grant the temporary restraining order. And it went up to the Court of Appeals, and the Court of Appeals heard the appeal from the Trump administration asking for what they call a stay of the
execution.
restraining order to still allow the deployment while the appeals are still going on. And the district court, the appellate court for the circuit of the United States Court of Appeals said, you know what, Trump administration, yeah, we're going to grant you relief, because here in the District of Columbia, unlike the states of the Union, the District of Columbia is not a state, and it doesn't, and there's a lot to unpack with that, but by federal statutes from the time of the founding of this country, the district is just a district, and it's run by the federal government with the executive, the president, running the show. Generally speaking, the Congress has to do, the appropriations and whatever, but the president is able to mobilize the guard and to protect the citizens. So in that case, Trump got his way insofar as being able, while it's on appeal, to still have the guard mobilized, because the court there, the appellate court said, you know what, as a finding, we have to show, or at least believe, a couple of different tests are going to be founded by, or at least cleared by the Trump administration. Among the prongs being the likely success on the appeal. And they said, you know what, likely that they're going to succeed, because based upon the federal statutes, president has the authority. It's fine. Now we move to the states, where the president has sought to mobilize and deploy National Guard troops to cities within the United States to protect federal assets. Department of Justice, the personnel, ICE agents, ICE facilities, because the president has been unable with the regular forces, as this is a quote, unable with the regular forces to execute the laws of the United States. And this is pursuant to Section 10, United States Code, Section 12406.
Right.
And there are appeals that were made in Illinois, Portland, and Los Angeles. So going through them has been very interesting. And I don't know what you found, Lou,
right.
But take a minute.
Yeah. So the one thing that I think is also that we need to make sure that people understand here as well is that the president's authority to mobilize forces under his Article 2, Section 2 powers as Commander-in-Chief, as well as the Insurrection Act, which Rob stated, the U.S. Code Section 12406, and other things, as well as the rulings that the Supreme Court had under Martin versus Mott, is that there's a difference between the president deploying National Guard units with consent and with the assistance and permission of a governor of a state versus not. And the big thing is that for those of you, giving a sort of a nutshell version as far as how the National Guard is different than other military units, is that the National Guard actually belongs to the state. They're mobilized by the state, and they're actually under the immediate authority of the governor of that state, where they can be called up under other federal action and other federal provisions by, the Department of War, the for the Coast Guard would be under Homeland Security, as well as the president for other actions, military specific actions. But as far as for enforcing the law or other similar actions, most of the time it's done with the consent and the agreement of the governor of that state. Like when they declare a national state of emergency or a state of emergency within the state, that's when the National Guard is mobilized with the consent of the governor. What we're talking about are in the situations where in LA, in Portland, in Chicago, they're going against it. The governor of that state is saying, no, we don't agree with this mobilization. And you don't have the authority to use our people. That's why if you notice that in, for Chicago, the president actually called up, or no, it was in DC, the president actually called up members of the West Virginia National Guard to come there so that there was no issue that they didn't, it's avoiding an issue. Let's put it that way. We could go down a rabbit hole to explain that, but let's, but the main thing is that this is when we're looking at it where the governors do not agree with the mobilization of National Guard forces.
And Lou made a great point to me off camera, which is we'll get to ultimately what the Supreme Court has said, in particular, a concurring opinion by Justice Kavanaugh. But the reason why National Guard units are being requested instead of saying, I'm calling in the 82nd Airborne, or, the 10th Armored Division to go in and keep the peace. The reason why they're using and seeking to use Guard units is because the Guard units are trained in law enforcement in addition to their military capacity.
Right.
And the basis, the alleged and claimed basis by the Trump administration is that these federal assets in different cities, Chicago, Portland, Los Angeles, etc., are under attack by civilians and ne'er-do-wells, and you could call whether it's Antifa or whether it's the local, whatever union, who knows what. And they are impeding the enforcement of the immigration laws. And the president is supposed to, among his powers in Article 2, is to enforce the laws of the country. And he's saying, whoa, I sent my Department of Justice through the ICE units to go out and get criminal persons who are either doing drug trafficking, children trafficking, whether it's they're here illegally, whatever it might be. They're trying to do roundups. They're trying to enforce the immigration laws, among other things. And they're being stonewalled here, there, with people blocking roads and throwing Molotov cocktails or whatever else he's alleging. And therefore, we need to have these Guard units here to supplement and help these ICE enforcement agents to actually do their job.
Right. And I mean, and going back to, the whole issue of cooperative versus non-cooperative, that the reason why there's a big difference here as well is because if it is a cooperative deployment where the governor agrees to go in and do these actions, then it falls under Title 30, what's called a Title 32 status, where it is a different federal law under 32 USC, and it's 502F specifically, where that deals with it, where it's saying that because it is being done with the consent of the governor and is not a full federal mobilization, but it's that the federal government is simply reimbursing the state for the expenses of doing this law enforcement action. The Posse Comitatus Act, which everybody's screaming, oh my God, the use of federal authorities, Posse Comitatus. And for those of you who don't know what Posse Comitatus Act is, it's basically saying that you cannot use federal military forces to enforce federal law, like to enforce the laws, because they wanted that this goes back to the writing of the back in the Constitution and everything else shortly thereafter, where people were concerned about using how the British did, using military assets to enforce the law. They didn't want that. So that's where the Posse Comitatus Act came up. But that only comes into play when it is a fully federalized action where the president is using it against federal authority, like without the state consent, without the governor's consent. And that's why you have the use of other federal assets, like, pulling in the West Virginia National Guard to go to DC or Chicago or someplace else, because then you're using a cooperating state and their forces to carry out this action. But that's a whole other can of worms.
Right. And the Posse Comitatus Act which is Section 18 U.S. Code 1385, which all of the stuff we're going to talk about, we're going to put as links so you can read it yourself. We never want to be the people who just talk at you. We want to talk with you. We want you to have the information. My recollection and understanding was this was enacted by a block of southern states after the Civil War and during the Reconstruction era, because they didn't want the federal government to come into their states and enforce federal law. So they didn't want federal boots on the ground and all this other stuff. So basically, it's really brief. It says, and in its current form, because they actually have a reference to the Space Force, which was not in place in 1878. Whoever, except in the cases under the circumstances expressly authorized by the Constitution or Act of Congress, willfully uses any part of the Army, Navy, the Marine Corps, Air Force, and Space Force as a Posse Comitatus, which just basically means a group of citizens summoned by a sheriff or a local authority to maintain public order, to execute the laws, shall be fined under this title or imprisoned, da, 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 da. So basically, it's, look, can't bring the federal troops in unless the Congress says so. So this has been a statute that has been brought up in defense of the lawsuits against the Trump administration for seeking to bring in National Guard units into these different jurisdictions. So what's interesting when you read these decisions issued by different jurisdictions, how they interpret, which is why it's so fascinating when you have different things from different countries and different circuits in different locations, and it goes up to the Supreme Court. Someone's got to make a decision, and at some point, this is all going to come to a head, and the Supreme Court's going to have to hit this head on. But right now, we're in a state where different restraining orders have been granted, restricting the use of National Guard units. The question then is, when the Trump administration comes in and says, hey, we understand you gave this restraining order, we want to stay. Meaning, that's fine, but until we have a full-blown decision on the merits, we still want to be able to utilize the National Guard units in the interim. And there's been a strange discrepancy between different jurisdictions. We have first, at least from my recollection, in Oregon in October of 2025. And for everyone out there who wants to listen, this is docket number 256268 out of the Ninth Circuit. Mm-hmm. State of Oregon, City of Portland versus Donald J. Trump. And the judges there on that circuit said, you know what? We're going to allow the Trump administration to stay, which was kind of surprising. Then we go to Illinois, I think it was the next one.
Yeah, that's the one that was just decided.
And there's also one out of California. And the one in Illinois basically said, no, we're not sure about this. Da, 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 da. And ultimately, as we had kind of, well, I'm glossing over this with a broad brush, and I apologize because you don't want to hear listening to us sit there and chat for 5 hours. Ultimately, there was a reference of all of this stuff to the United States Supreme Court. And this is the Illinois case that reached the Supreme Court. Right. And this was on December 23rd of 2025. And there, the justices of the Supreme Court had a very interesting question. They said, well, hold on. Before we get to the issue of whether or not we should grant a stay, the government has said in calling forth the Guard, the president's relied on this particular statute, Article or Section 10 of the United States Code 12406, which is entitled National Guard and Federal Service. And the president relies on this and says that he needs the guard to be basically to protect and secure the safety of federal assets in the execution of their duties. But the statute speaks to, and I'll read it, the president may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. Orders for these purposes shall be issued through the governors of the states, or, in the case of the District of Columbia, through the commanding general of the National Guard. Now, the Supreme Court, in their statement, said, and I'm quoting again, in calling forth the Guard, the president relied on this particular statute, 12406, which empowers him to federalize members of the Guard if he is, quote, unable with the regular forces to execute the laws of the United States. So the Supreme Court said, whoa, as a starting point, what does it mean by regular forces? And there was a split between Illinois and the Trump administration, whereas, and I'm going to get my notes out here, Illinois said, well, that means the U.S. military. And the Trump administration said, no, it's not the U.S. military. It's local enforcement agencies. It's some of the Department of Justice. And the Supreme Court said, no, it's the United States military. That's what we're really talking about. And again, painting with a broad brush, you can read the decision. It's going to be in the comments. The majority said, we're not going to grant the stay to allow the Guard to stay in place pending these appeals, which will still be percolating. And that was a little bit of a blow to the Trump administration. But the interesting thing about this case is the concurring opinion by Justice Kavanaugh. And Justice Kavanaugh said, look, I agree with the ultimate decision given by my colleagues here, and I'm on board with it, but I would have done it in a much more narrow purpose, because the way that it's written here, it really handcuffs the president in his Article 2 duties to be able to secure and to enforce the laws of the country. Go ahead, Louis. I know you're going to say something.
I was going to say, no. That's, but I think that's exactly on point. Is where the narrow reading of it is that they're basically saying, looking at just that specific section, you need to use the regular military, and that's something that was never contemplated by anyone, really. I think and I think that with the way the argument that Rob's making is actually on point with this, where the reading of that 10 USC 12406 it specifically says the regular forces, and I think that the Trump administration's reading of it is more appropriate. But regardless, that really created an issue. And we can make arguments on this, and I'll let Rob finish up on his thought. But as far as other provisions, such as, my whole thing would be that the Insurrection Act is the one that's the most appropriate claim in this, beyond the normal Article 2, powers that under Article 2, Section 3, the main specific one, since that's that's the one that has to do with the take care provision. And for everybody that's listening right now, we actually have a full discussion on the Article 2 powers, which is being released at, the same time as this. We just wanted to get this in because, again, as we talked about before, and if you saw our last episode where the last special report that we did on the invasion of Venezuela, that's another one where we went into similar issues as well. So this is the Article 2 session, basically on steroids. But anyway, go ahead, Rob.
So with regard to the opinion from the Supreme Court, they disallowed the suggestion from the Trump administration to grant a stay. And they spoke to the fact that I'm reading from Trump v. Illinois. Under the Posse Comitatus Act, the military is prohibiting from executing the laws, except in cases and under circumstances expressly authorized by the Constitution or Act of Congress. So before the president can federalize the Guard under 12406, he likely must have statutory or constitutional authority to execute the laws with the regular military and must be unable with those forces to perform that function. And that was a bridge too far for Justice Kavanaugh. And he says, while I agree with the fact that the stay shouldn't be given, I think that it should have been granted on narrower grounds. And he gives a great example. He says, the problem in my view is that meaning the court's view and the decision here was way too broad. And he talks about this example, and he says, suppose there's a mob threatening to storm the courthouse in Philadelphia, federal courthouse. They want, because of some highly charged emotional case. And they've claimed that they're going to kill the prosecutors and all of the federal bailiffs and everyone in there. They think that this, whatever. And the U.S. military forces cannot readily mobilize to deploy in time. Why can't the president authorize the National Guard to get there? According to what was just said by the justices previously, with their more broad interpretation, you can't do that unless Congress gets in and says something. And as we all know, by the time Congress does anything, one way or the other, it takes forever and a day.
And we've already seen that in Portland, and I mean, almost exactly on point happened in Portland, 2-3 years ago. So,
right. So in one of his footnotes, and this is on page 5 of the decision, he says, as I read it, and this is Justice Kavanaugh, the court's opinion does not address the president's authority under the Insurrection Act.
Right.
Which is Section 10, United States Code 252 and 253. For those of you who are looking, because we'll have that in the comments as well, so you can read it for yourself. Justice Kavanaugh continues, moreover, the court's opinion does not address or purport to disturb the president's long asserted Article 2 authority to use U.S. military as distinct from the National Guard to protect federal personnel and property, and thereby ensure the execution of federal law, which is, of course, mandated of him by Article 2 of the Constitution. And he continues, and he cites a Professor Goldsmith talking about how the protective power is the president's inherent independent Article 2 authority, and he can invoke it any time, whether or not Congress likes it or not. So what Kavanaugh is saying, and everyone needs to understand, is, hey, wait a minute. There may be reasons why you call in the National Guard. And even if you just say that's not appropriate at this particular juncture, you understand you can't handcuff the president under his Article 2 authority to use and invoke the Insurrection Act, because he can call in the military, the 82nd Airborne, 101st, the 10th Armored Division, whatever it might be. And, Congress be damned, and everyone else, because you'll hear all these talking heads as we have. Oh, you can't put American, military in our own country. It's unconstitutional. No, actually it is, and it can be. So when you hear someone say that it's unconstitutional, ask them, well, what part of the Constitution are you referring to? And if they can't answer it, that's red flag number 1, because Article 2 is specific, and it delegates the authority specifically to the President of the United States, the executive, to enforce the laws of the United States. Period. End of story.
Right.
So this is going to be percolating through the courts, as I suspect, as we both suspect. This is not over with, because there's a split of authority with regard to the lower courts as to whether or not the president has the authority to provide the Guard units, whether the stay has been granted or not been granted. It's going to continue to percolate, and ultimately it's going to be addressed on all fours by the Supreme Court. But for now, understand, please, the Constitution does give the president the authority to enforce federal law.
Right.
And as I've told my kids from the time they could understand language, we can do this the easy way, we can do it the hard way.
Right. And I think that the other most important thing that people also have to understand is that this was not a full decision on the merits. And I know we
Right.
mentioned it before. This is just simply whether or not the Trump administration was entitled to a stay of execution of the restraining order that the state of Illinois, the state of Washington, the state of California sought, or the city of Portland, the city of Chicago, the city of Los Angeles. That there wasn't a decision on the merits. So when people say, oh, the Trump administration lost, no, this was just simply a temporary setback. Now, whether or not it becomes moot, and that's another thought that, that we may not get this ever finalized or decided upon, because it may become moot at that point, which means that the Trump administration may decide, look, we're not going to try and push this forward. We're withdrawing our troops, which they've already have out of Chicago and out of some of the other areas that are not cooperating with his call up. So for the places that are like Memphis is still cooperating. They're still agreeing to it. And so because of that, those National Guard forces are there. DC is still cooperating because he has that authority. These other places, they may not, and that it may be mooted by him just saying, you know what, let it burn. We're pulling our forces out, and and FAFO, but
in going through the research of all this stuff, there were a couple of things that came up to me as questions.
Right.
Well, all right. So I've read the United States Supreme Court decision on this particular issue of the stay. Okay. Well, what if a governor, and President Trump has said this on any number of occasions, anytime he gets to a podium with a microphone, it seems like he makes some reference to, well, I don't understand why they wouldn't want us there, and that kind of stuff. But if there was, for example, a governor, let's just say, what happens if, for example, Illinois, for whatever reason, however it would come about, the Governor Pritzker decides, I'm going to retire and I'm going to go play golf, and there's a runoff election or something like that, and a Republican gets involved. And the Republican governor says, I want the federal guard to come to Chicago. And the mayor says, no, we're a sanctuary city and we don't want them here.
Doesn't matter.
Well, how does that play out? What the reverse? What if I think it's Mayor Johnson or Johnson in Chicago, say he says, I'm retiring, I'm tired of this BS, I'm going to play golf. And they have another election and a Republican comes in. And he says, or she says, look, I want the federal guard to come in because Chicago's it's terrible. I want to make sure we can use the federal guard, the National Guard, to our benefit. But Governor Pritzker says, it was the Democrats, says, no, I don't want them there. Then what? There's a whole bunch of stuff with sanctuary city stuff, who whether it's a governor or a mayor, whether they want it or not. Again, it still comes down to, in my particular view, as it always does, we talk about on this particular podcast, the legal basis, which comes down to the constitutional bearings. Right. Article 2, the president has the authority and the responsibility to enforce the laws of the United States.
Right. And I think that, taking that argument that you've just put forward even further, and as I brought up before, one of the big issues, though, is that, and I think is being overlooked here, is where the units are originating from. The governors of these states only have the authority over their own specific state. So if you bring in a unit from a different state to do this, what authority does that governor have over the use of National Guard units that are not under his authority? And
Right.
I think that's something that's really being overlooked. And that's another, as we talked about the last, in our last special report, when we had to do with Venezuela, there's a lot of things that I think that if this gets to the Supreme Court, that it may not, I mean, it'll be interesting to see how this all comes out, because this is something that I think that we really need some more clarity on, because a lot of these things have never been addressed. I mean, the last time that you had anything like this addressed was back during the 1960s and the civil rights movement, and then even before that, back in the Civil War.
Well,
I
think
mean,
about this. I think that the district court judge in the California case was a gentleman by the name of Judge Breyer, and I think he made some comment like, this is the first time the Posse Comitatus Act has been brought into the federal courts since 1878 or something like that.
right.
You know, these laws have been on the books, but they haven't been enacted. They haven't been utilized. They haven't been dusted off. And hey, look, we can use this, or this, or this needs to be a defense for this, or this. These are things that are now being tested. Again, we talked about this during the last special edition. This particular administration is pushing the boundaries, whether you like it or not. And it's actually a good thing, because we need clarification, because things have changed over 50, 75, 100, 150 years. We need to have clarification about Article 1, Article 2 powers. How can it be utilized? When can it be utilized? Should it be utilized? When it cannot be utilized? How it's utilized? All that. And this particular issue that we're bringing up today is going to, as Lou says, more than likely going to wind up in the steps of the United States Supreme Court on its all fours, not just with regard to the
Restraining order.
stay that where we are now.
Right.
And they're going to say, we need to have this heard on the issue fully. Can the president do this? When can the president do it? If he can. If he can't, why not?
And yeah, and that I think that beyond that, it's also going to come to an issue of, you know, the hierarchy of the rules. I mean, even though that we have the Posse Comitatus Act out there, and even though we have the Insurrection Act out there, you know, the Insurrection Act is the one that provides the power. The Posse Comitatus Act is one that limits the power. That it all comes down to what the Constitution is. It doesn't matter what the statute says. If the statute violates the Article 2, Section 2, Section 8, Section 3 authority of the president, doesn't matter, because the Constitution trumps all. But
did it again. You did it again.
But so that's really, so even though there may be a statute out there that may go to try and limit the president's authority, if the Supreme Court interprets the Constitution as an original, as originalist or a purist, they may say, well, yeah, okay, that's what the Posse Comitatus Act says, but under Article 2, Section 3, take care clause, that's unconstitutional. And then, you know, then that maybe, then there's a whole other issue.
Right.
Oh, goodness. See, that's why, we both love doing these special report things, but we also love talking about this, because this is one where every week brings up something different, and there's always something new, and there's always something great to discuss. And, you know, thank you all for your comments and for your suggestions that, you know, reaching out about some of the things that, to cover, because that really gives us an idea to shape this.
And thank you for the grace. I know, and we've been trying to blend this into a relatively distilled,
right,
manageable time frame. And when you have federal cases that are in 4 different jurisdictions with case law, I apologize if I was all over the map at the beginning of this, trying to blend it all into one. And people are like, what the hell are you talking about? You're all over the map. Literally, I am all over the map, because we're at DC, we're at Illinois, we're at Oregon, we're at Los Angeles. The long and short of it all is, we need to be able to have some clarification on this. We are here, Lou and I, trying to say what we think with regard to what we're seeing in the constitutional text, in the federal statutes, it's going to be very interesting whether or not ultimately the National Guard will be able to be used by a president, whether it's Trump, whether it's whoever his successors are in the future. Where I sit looking at this stuff, I understand the Posse Comitatus Act is there and why it was there from 1870 something. Quite frankly, I don't think it's constitutional.
Right.
I understand that it's there for XYZ, but if it flies in the face of Article 2 powers given to the executive to enforce the laws of the United States, I don't see how you can have a world where they exist side by side.
No,
I just don't.
I mean, you couldn't have summed it up more appropriately. I mean, I agree 100% that there's, there's a reason behind it, but simply because there's a reason doesn't mean that it's something that's going to fly. But it'll be
Well,
interesting to see.
and I think that I haven't delved head, arms, shoulders, feet into the Posse Comitatus Act insofar as how and
Head,
why it
shoulders,
was,
knees and
yeah,
toes.
head, she said toes. But from the brief description of things that I've read about it, it was really an accommodation to the southern bloc of states that, well, okay, we'll let this go. Because we don't want, we remember the Civil War, which was at that time 20 years prior. We don't want to go through that again. Look, you just do it. We're not going to try to overstep our bounds from the federal government perspective. You do you, we'll do us, and we'll just be fine. That doesn't cut into constitutional,
Right.
Into a good constitutional setting. As far as I'm concerned, like I said, Article 2 trumps anything that's in a federal statute. I'm sorry for the Trump thing, supersedes, overrules, whatever. It'll be interesting to see what this comes with. And as we talked about previously, as Lou had pointed out to me before we hit the air, the reason why we even are looking at the National Guard going in is because they are the ones who are also trained in law enforcement techniques and not just, a blunderbuss that would be the 82nd Airborne or, the 10th Armored Division or whatever it might be. There's a reason why they're asking for the National Guard units. And if federal law is being impeded to be enforced, that's the underlying issue.
Right.
It shouldn't be impeded. And people can protest about this, that, or the other. But I would be surprised, for example, if there was the same level, and I know I'm going off on a tangent and I apologize. If there was for example, like the law in Law and Order, there's the SVU unit, right? They go after all these people who perpetrate sexual violence or, domestic violence. If for whatever reason there was a band of people who said, you know what, they disproportionately go after white males, or they disproportionately go after black males or Puerto Rican males or whatever, we're going to block their vans and we're going to I would have a hard time believing people would be in support of that. Law enforcement is important, and it's part of the United States Constitution insofar as making sure that the laws of the nation, the federal laws, are enforced. It's not a suggestion, it's a law. You can, if you don't like the law, work through the channels to amend it.
Right. Like we said before.
And again, I'll get off my, at the risk of getting on my
soapbox,
high horse, soapbox, whatever. But this one seems to me to be somewhat cut and dry. That's
right.
just me.
Right. No, absolutely. And I think it's something that, like I said, it'll be interesting to see where it comes out. If it's something that the administration continues on with to try and force a decision on this, or if they'll just, cut their losses, let this go moot, and just go in these cities who are willing to cooperate with them.
Well, and again, there are two parts of this. One is the District of Columbia
Right.
view of we're trying to save the city from being a criminal problem.
Right.
We're trying to protect the citizens because their cities are rife with crime. That's one aspect of it. The other aspect, which has been provided in, for example, the Oregon case in particular, and the Los Angeles case, it isn't that not just that your cities are rife with crime. It is we're trying to protect the federal assets that have been sent there to enforce the laws.
Right.
And we're bringing the National Guard in to protect the ICE agents or the Department of Justice agent, whatever it might be. So while people may see it as one action and that's it, they're two different purposes.
Right.
But either way,
100%.
and again, with regard to District of Columbia, real cut and dry, because the executive has the authority talking about National Guard units into policing and all the other stuff with regard to the District of Columbia. Done, over. Well, I shouldn't say done and over. At least where we are now, it seems to be cut and dry. Everywhere else in the country will be interesting to see.
Absolutely. And with that, I think that we've hit that point.
Something about a dead horse.
Brain drain.
Something about a dead horse.
No, but again, this is an important issue. It's one that we really will be interesting to see how things come about. I think it's something that the states also have to be careful about. I mean, I'll add my 2 cents on it, and then because I don't want to circle back around. I don't want to be that going around the drain. But just remember that using the National Guard and using them as assets, the governor also needs to get permission from the president and Department of War to use them to their benefit. So it may be something that they may decide we're to declare a state of emergency, and the president could always go back and say, yeah, about that. No, under Article 2, I have the authority, and I have to grant permission for use my forces because you're asking permission for me to use them. And I don't have to grant that. So, this may be, this is something that these states have to be careful about as well. I'm hoping that would never come to pass, but I'm just saying that that's something that is also the authority of the president as well. With that being said, I think that that's about it. Right, brother?
Lou, you rock as always.
And you do too. And we appreciate you guys. Appreciate everyone sticking with us. I know that, again, these have been the long rants, but this is something that it's hard to condense something like this with all the issues into half an hour, that we normally try to do. So, but
for everyone out there, like we said, we always try to provide the underlying documents, information into the comments so you have it for you. You're going to see the District of Columbia opinion. You're going to see the United States Court of Appeals for the Ninth Circuit opinion. You're going to see the United States Supreme Court opinion with regard to these stays.
All the statutes,
the Posse Comitatus Act, or the Section 12406. All that stuff's going to be in there. We encourage your comments. We encourage the dialogue. Please like, subscribe, and share this.
Right.
But also comment. Seriously. Right. We really do. We read all the comments. We really take it to heart. And thank you for the continued viewing, listening, commenting,
support. We're up, brother. Thank you all. Remember, the Republic, if you can keep it podcast.
If you can keep it.
Signing off.
Shut up and sit down.
Thanks for listening to The Republic, If You Can Keep It podcast. Join Rob and Lou in our next episode as we continue our riveting discussions on the most important topics affecting our great republic. Drop a line for topics you want to discuss, and don't forget to like, subscribe, and share. Until next time.